Hi, it's Mike DelSignore. I want to talk about what happens if someone tries to take a 209A order out against you. So 209A is a domestic restraining order. Essentially, the person's trying to get an order preventing you from abusing, contacting them, or having any contact with them. A violation of this order is criminal offense. So if someone gets an order against you, it's a 209A no contact order. It means you can't contact them through third party, directly, indirectly. If you make any type of contact with them, you're going to be subject to criminal penalties. And once the 209A order is taken out against you, you have to surrender all firearms, any kind of weapons. So if you have a license to carry, you're going to have to surrender your firearms. So there's a hearing on it. So what generally happens is somebody's charged with domestic assault and battery, and then the victim will try to get a 209A order. If you're charged with a domestic, it's generally unwise to try to fight the 209A order. Almost all judges are going to issue the order against you. To really contest the order, you'd have to testify. Whenever someone's charged with a criminal offense, it's unwise for them to testify because anything someone says can be used against them in court. So as someone charged with a crime, it's a bad idea basically to try to contest a 209A order. It's not beyond a reasonable doubt standard. It's a very low standard. Most judges are going to issue the order anyway. Now you've created testimony that can be used against you at your trial or further court hearings. So typically the best approach is to let that order get issued. It will generally be issued for either 6 months or for a year, and then hope that it expires after and work on getting the case dismissed. Sometimes if you don't have any contact with the victim, you abide by the order, that could go a long way to working these cases out. So if you have a 209A order taken out against you, feel free to call me. I can tell you the best ways to approach this. These orders have affidavits in them, and we can use that affidavit in order to contest the underlying domestic charge if there is one. If you're charged with violating one, feel free to call as well. We handle those cases as well. There's a lot of different arguments in terms of whether you notice of the order, whether it's a violation, was it really indirect contact, what's the significance of the contact. Generally, that's not a defense. If it's like de minimis, there's not really a de minimis exception, but it certainly goes towards how the violation might be viewed by the district attorney. So my name is Michael DelSignore, handle criminal and domestic cases all over Massachusetts. We have offices throughout Massachusetts in Stoughton, Attleboro, Westboro, New Bedford, and Marlboro. I'm well known in Massachusetts courts for handling these cases, and I'm here to help you out. Feel free to call anytime. It's never too late. Don't worry about weekends, holidays. If you don't reach me, leave a message. You can even text. My cell 781-686-5924. And if you have questions, feel free to call. I'm here to help. Thank you.